The ill-fated tourist boat that sank on the Danube River in Budapest last month finally emerged to surface today, 2 weeks after the accident. The stern of the boat was badly damaged, and 4 bodies were found at different locations inside the boat, 3 of whom are presumed to be South Koreans. This while an investigation is ongoing on the captain of the cruise ship, the Viking Sigyn, that collided with the boat and caused it to sink. Today, we go in-depth on the latest developments of the salvage operation and the remaining legal issues of the investigation. For that, Dr. Kim In-hyeon, a captain and a professor at Korea University School of Law, now joins me in the studio. Thank you so much for coming in today.
Good afternoon.
Now, the tourist boat finally emerged to surface after 13 days. On the Danube, after colliding with a bigger cruise ship, how did you see the lifting operation so far?
I'd like to express my deep condolence to the family of dead or missing passengers at the Danube tragedy. Today I saw the TV on the situation of lifting operation for the sunken boat. I thought that it was carried out very smoothly so far.
So it was a smooth operation so far. What do you think are some of the remaining procedures to follow after the boat is completely salvaged?
Yes, I think that the boat should be kept intact for further investigation to find out the cause of the accident.
So the boat should be, it's important that the boat stays intact until further investigations are carried out.
That is my idea.
Now, I understand that you are a captain yourself, and you have specialized in maritime law. What do you think was the main cause of the accident in your perspective?
Yes, I think that the tourist boat Mermaid was rapidly capsized due to collision with the Viking Sigyn. Because the Viking Sigyn, which was 10 times larger than the boat, collided stern of the boat, and caused the boat capsized. And unfortunately, it seems that the passengers on board the boat didn't have any opportunity to escape from the sinking vessel.
Yes, we hear that it only took 7 seconds for the tourist boat to sink. And unfortunately, I'm sure the victims had no idea of what was even happening at the time of sinking. Now, who can we say is legally responsible for the accident at this point? Or are there multiple individuals or parties that have legal liability? Yes,
both captains of the tourist boat and the Viking Sigyn they contribute to the collision accident and caused the loss of life. It is called as the mutually committed tort. Under mutually committed tort, the victims has a right to make a claim, any obligor. I think in this case, the owner of Viking Sigyn is deep pocket, and so the victims of the tourist boat may make a claim of full compensation against the owner of Viking Sigyn.
So there is both the captain of the capsized tourist boat as well as the Viking Sigyn cruise ship have mutual responsibility.
Yes, mutual responsibility. However, the owner of the tourist boat and the Viking Sigyn are vicariously liable.
Now, Hungarian authorities are holding in custody the Ukrainian captain of the Viking Sigyn that collided with the tour boat. Could you explain to us what kind of charges he faces and on what grounds?
Yes, I think there are 2 grounds. The captain of Viking Sigyn seems to commit involuntary manslaughter because he caused the collision accident and led the passengers to the death or loss of life by accident. it is one of the ground, and it seems that the captain of Viking Sigyn violated narrow channel navigation. So
Narrow channel navigation.
that is the another ground for the penal liability.
Now, through videos released after the accident, we later learned that the Viking Sigyn returned to the accident site but didn't make any rescue attempts. Now, I understand that according to the Korean law, this could force the Viking Sigyn captain to face up to a life sentence. Do you think the video can be a big factor in the ruling process?
Yes, I think the videotapes will play a good evidence for such the criminal charge. The ship's captain has duty to rescue the persons in danger at sea when the captain involved in the accident. As you explained to me, according to Korean law, if captains failed to exercise a rescue operation, he is subject to life imprisonment. I think that the Hungarian criminal code may be very similar to Korean one.
So captains are legally responsible to rescue people when they see the need to.
Yes.
It's a legal responsibility.
This legal responsibility, according to Korean law, I am not sure about the Hungarian law. However, according to Korean law, the ship's captain has a legal obligation to rescue the person in danger.
Now, the captain, however, continues to deny all charges against him and is now demanding a bail. But we've also learned that the captain has deleted data from his phone between the time of the accident and the seizure of his phone by the prosecution. Do you think he can be granted a bail, even so?
Even though I'm not sure about the Hungarian Criminal Procedure Act, there is a high possibility that he will not be bailed because there is the danger for him to erase the evidence detrimental to him.
So a bail is unlikely to be granted.
Yeah.
The Hungarian prosecution has the investigative rights, but since most of the victims were South Koreans, do you think there's a possibility of a joint investigation between the South Korean and the Hungarian prosecutions?
Yes, the accident occurred within the territory of Hungary, and thus we can say that the Hungarian government has exclusive criminal jurisdiction power. So the Korean government is not allowed to exercise the investigation power or indictment in Hungary. However, Hungarian government may invite the Korean government to carry out investigation together, taking consideration that about 30 Korean the peoples involved in the tragedy.
So upon our request, it could be possible to form a joint investigation team.
I understand that one or two experts from Korean the Maritime Investigation Agency has been arrived at Hungary to carry out a co-investigation with the Hungarian government.
Now, following this deadly accident, many have raised the point that traffic on the Danube River, especially during the nighttime, is almost life-threatening. Now, could you tell us what kind of laws are applied to ferry operations on rivers normally?
Just as the driver on the road should keep the traffic law on road, the captain on board at sea or river also should keep the traffic law at sea or river. Also Danube River is regarded as a narrow channel. The Danube River is regarded as a narrow channel because channel is very narrow.
Right.
So,
and that's what makes
yeah,
things
yes,
much more dangerous.
much more dangerous. So in a narrow channel, the overtaking vessel is required to get permission from overtaken vessel. In this case, the Viking Sigyn was overtaking vessel, and the tourist boat was overtaken vessel. So Viking Sigyn, as overtaking vessel, should have get permission from the tourist boat as overtaking vessel. But it is reported that the Viking Sigyn didn't have such permission from the tourist boat.
So even though Viking Sigyn was the overtaking boat, it did not get a permission that was necessary.
Yes.
Now, if the bereaved families of the South Korean victims decide to claim for damages, who should answer the claims? Is it the travel agency or the tourist boat company or the cruise ship operator?
Yes, it is a good question. The Korean tourist or family of victims may have several cause of action. There are several parties to answer the claims. The first Korean tourist entered into a contract for the carriage on board with the operator of tourist boat. The operator of tourist boat should exercise due care to protect the passengers. If the tourist boat owner or operator not prove his exercising of due diligence, he may be legally liable for the death of passenger. That is one of the cause of action. And the other ones comes from the tort. As I explained to you, the boat of a mermaid and the Vikings, the captains, mutually committed tort against the victims. And the victims are allowed to make a claim. Any obligor, in this case, the owner of the Viking Sigyn and the owner of a tourist boat. That is the second cause of action. The third cause of action comes from another contract. The tourist company had a touring contract with the passengers. And touring company has obligation to exercise due care to protect the passengers, a tourist in this case. If the court find there was the fault or negligence from the side of a touring company will be liable for the death or missing of their tourist. That is the last cause of action.
Now, one last question for you. Foreign Minister Kang Kyung-hwa visited the site on the third day since the accident. Yes. What's your assessment of our government's initial response as well as efforts made as days progressed?
I think that it seems that the Korean government responded very swiftly to the tragedy, and thus the procedure was done very smoothly.
All right, thank you, Professor Kim, for your insights tonight.
Thank you. Thank you so much.
And that does it for this edition of News in Depth from all of us here at Arirang. Thank you for watching, and I hope to see you right back here same time tomorrow.